Everybody, and welcome to another episode of What's Up With Us, the Real Property Law Section webinar, not really podcast, whatever this is, right? Right, Ashley?
Yeah.
We have two guest speakers today. We have Ann Landfar and Jillian Van Uden. So we're going to kind of jump right into things today. But I don't know, Ashley, if you have something you want to talk about before we jump into our substance, go ahead.
No, I was just going to give a quick recap of the wellness retreat, which was a super big success and a lot of fun. The one up in Tahoe, the wellness retreat for the real property section. We had over 100 people attend. And Neil, any thoughts on the event?
Well, I happen to love it. To me, it was so well designed. Really a perfect mixer, a perfect balance of a little bit of substance, a lot of networking, really good food. So it was really, I thought it was a perfect blend. I'm so happy, we did it this year, and I hope, you as part of the committee are going to encourage the real property section to do it again next year.
Yeah, I hope we can do it again next year. I enjoyed it. I think we had such a phenomenal vibe and energy at that event, and I think that will continue in the momentum. So,
well, wonderful. I'm so glad you said that. That was a great way to start. So let's see, what are we doing here? Here's our agenda today. We've got two cases. We've got, as I say, two guest interviewees today. And if we have time, we'll talk about what's going on with the Attorney General and housing and SB 9 and SB 10 and what that's doing with local governments throughout the state. And we've got two experts on that. So we're in really good shape here. And let's see, we always like to start off with what's going on with May. And of course, we already passed Mother's Day. May is Mother's Day. And we're going to be coming up to Memorial Day. And also in May, there's either Armed Services Day or Armed Forces Day. I see it called a couple of different things. And so we celebrate those who, and we remember those who serve and unfortunately are not with us anymore, and those who are currently serving. So I kind of like May. It's really a nice mix, and remembering those who are important to you. So that is our What's Up with May. And let's jump in. If I can get my screen to change. Oh, there we go. Changing a little bit too much. Let's start. We're going to start with Crenshaw Subway Coalition versus City of LA. And let's see what we're going to be learning about today. This was, okay, now I remember this case. Yeah, here we have a case where the City of Los Angeles approved a revitalization project in South LA. Part of a shopping mall was being torn down. It was being replaced by really mixed use office space, hotel, apartments, condominiums. The local neighborhood group sued to stop the project, says it was discriminatory under both the federal and the state Fair Housing Acts. I've got the sites up there. And kind of an interesting, approach. The lawsuit basically says, we think this project is going to be successful. And if it's successful, what's going to happen? It's going to lead to gentrification of the area. All of the things that the city wants to have happen, right? Bring in more affluent residents, increase property values. What comes along with increased property values? Increase rent. And the neighborhood group, the Crenshaw group, says, well, wait a minute, but the result of all of that is going to push low-income residents that are living near the area, because the area that was being revitalized was not a residential area. It was all commercial, where they said the surrounding areas, it's going to have these effects. That's going to be discriminatory. There was two basically neighborhoods in the area. And looking through the case, you see the information about those areas. And although the percentages are different, both areas had a mix of Black and Latino or Latinx residents amounting to 90% of the residents in those areas. So they say that the percentage was a little bit different depending on which neighborhood. And so the Crenshaw group says, well, wait a minute, these people are going to be forced out. That means this project is going to have a discriminatory impact. And that creates a violation of, or it will create a violation of the federal and state Fair Housing Acts. The city demurred to the complaint. Originally, the trial court denied the demur, so the trial court sided with the neighborhood group. But after that happened, an appellate case came down, and you see it later there, the AIDS Healthcare Foundation case, that said, well, wait a minute, gentrification is not a viable theory. Under the Fair Housing Act, the city applied for reconsideration. The court said, yes, well, now with this case, we have to reverse our decision. We're going to agree with the demur, okay, and get rid of the complaint. Of course, the neighborhood group appealed. The appellate. Meanwhile, what happened after that? What happened after that is the appellate case was depublished, right, by the California Supreme Court. And so the appellate court said, well, it doesn't really matter that it was depublished. That's the first part in the appellate decision section here. They said, guess what? It was good law, and the fact that it was depublished does not mean that the Supreme Court disagrees with its reasoning. In fact, under California law, it specifically does not mean that. And so the appellate court said, no, we think the reasoning is still valid. The court said, also, we don't want to get involved in these political decisions about what's the right way to be involved. Those are decisions for the legislature. And kind of that third point there under the appellate decision, to me, was really kind of the most interesting part of this opinion, which basically it said, well, wait a minute, Crenshaw Coalition, basically what you're arguing is that these two areas are essentially segregated areas, and you want to keep them segregated. Well, that is completely antithetical to the Fair Housing Act, which is supposed to promote integration. And so you're saying you're violating the Fair Housing Act by having a segregated system and maintaining a segregated neighborhood. So I thought it was a really kind of interesting case. They looked to U.S. Supreme Court authority. And, Ashley, what do you have to say? And either Ann or Jillian, if you want to join in, you're welcome to do so.
Yeah, I mean, I agree with your thoughts. I mean, it seemed like they came to the right conclusion on this one. I mean, obviously, you can't prevent gentrification from happening, and like you said, encouraging the segregation is not in the benefit of the city or the Fair Housing Act in light of that. So, I don't know. Ann, do you have any thoughts?
Well, I'm glad they made this ruling because it would make planning impossible in cities, because if this became another factor to consider, and it's everybody's perspective of it, it would be really difficult for any projects to go forward.
I agree with what Ann has to say as well, because the concept of a disparate impact, which is really what they were looking at here, is the third rail that we advise our planning commissioners and our city council. You don't want to have any appearance of a racial animus or a discriminatory intent in your decision making. And so this decision would invite that type of analysis. I just wanted to add one other thing, because a lot of what I do is entitlement work, and that involves California Environmental Quality Act. One of the components of this case was a CEQA challenge, and it was brought too late. But one of the issues, so it was a statute of limitations prohibition to the CEQA claim. But one of the interesting pieces of that discussion, although it wasn't a published part of the discussion, was that where you have a series of actions that you need to take, the first action approving the project, in this case, the environmental impact report, is dispositive, so that the subsequent actions do not require or open up the possibility for a secondary or tertiary CEQA challenge. That first environmental impact report, to the extent the project hasn't been modified, obviously, covers that entire project. So that was sort of an important, I wouldn't say double down, but that is the status of CEQA law. It was nice to see this court just confirm that as well.
So now that you raised that, Jillian, I want to ask you a question. So given that you think that that was an important part of the discussion, do you think that the only reason that portion was not published was simply because of a straight statute of limitations? Or do you think the court found that it didn't really want to go that far?
No, it was really straightforward. It was a straight statute of limitations issue, but it's always great when you read a court properly interpreting CEQA jurisprudence. So I just wanted to note that for the record.
Well, there's all sorts of difficulties in getting projects approved, right? And so this case brought two of them to the forefront. It brings CEQA, for those who are able to see the unpublished portion of the opinion, and it brings the discriminatory impact forward too. And I know, our two speakers know a lot more about many other impediments to getting developments approved, and maybe when we have your individual interviews, you could raise some more of that, or at the very end when we talk about what the Attorney General is doing in SB 9 and SB 10. So thank you both for your input. Great to hear. Anything else before we move on?
Well, I just wanted to note that Texas Department of Housing and Community Affairs case that was a U.S. Supreme Court case, one of the when the second district looked at that case, what they found was that in some the FEHA and FHA laws were established for the purpose of eradicating historically entrenched segregated patterns and discriminatory practices within the housing sector that exclude minorities, not preserving existing minority majority communities. So I thought that was, an important illustration of how they were looking at this and why they ruled against the Crenshaw group. So that was it.
Yeah. So again, looking at the, what's the purpose of these laws, right? Essentially, and trying to be consistent with that purpose. So thank you for bringing that to everybody's attention. And you know what? We have you not on mute right now, Jillian. And we're going to start off our interview with you. So I'm going to turn it over to Ashley to learn more about you, Jillian.
Thanks, Neil.
Thanks, Neil.
Hey, Ashley.
Hi, Jillian. I'm so happy to have you here and that I get to interview you, because I've gotten to know you through the Real Property XCOM for the last, I've been on it for 5-6 years now. So I've had the pleasure of getting to know you on a more personal level, which I have loved. So why don't you let our viewers know a little bit about who you are and what you do?
Gosh, where do I begin? I've been with the city of Glendale for 25 years, so I'm a long haul employee at this point. I specialize, as I indicated before, really in land use, entitlement work, CEQA. I started off as a criminal prosecutor. I came out of the DA's office. Before I went to law school, I worked as a city planner, so that was really the locus of my interest were along the lines of land use city planning. So that came in very useful for purposes of code enforcement. I could direct folks to where they needed to be. I understood the processes they needed to undertake in order to fix their problems. And so that was gratifying. But then back in the late 90s, redevelopment was hot, and I got scooped up by our redevelopment agency and ultimately became their general counsel, which drew me further and further into understanding the practice of real estate transactions. And one of the reasons why I joined the then State Bar Real Property Law section was so that I could pick the super smart brains of all the transactional lawyers in the section to understand mezzanine financing and all of these sort of, things that were foreign language to me at that point in time, so that I could do a better job working on the various transactions. And as we all know, redevelopment was fabulous until it was not, and the state kicked the legs out from under it back in 2012, and then I spent the last 10 years actually now helping with the unwind and the dissolution. So fortunately, we still have economic development. So a lot of what I do is work with our planning department, building and safety, housing, and economic development folks to find money and do things with it that are beneficial to the community. A lot of that recently had to do with how do we keep our local businesses afloat? Can we do programs to assist small businesses, to funnel grants and various types of money through to them, and to alfresco dining? I mean, who doesn't love eating outside in our lovely weather? So putting together a lot of agreements to facilitate those types of activities. A lot of what I'm doing right now is secret defense work. We are well, let's just say a full service city, over 200,000. We have our own police and fire departments. We have our own municipal utility. Because of my experience and background in CEQA, I've had the, I don't know if I want to call it the distinct pleasure, but certainly the interesting challenge of looking at CEQA documents related to the repowering of our Grayson power plant, which was built back in the 1920s. It's a gas-fired plant. Anything that is fossil fuel powered is, of course, very controversial, and anything that replaces that power with something that is fossil fueled, even if it's reduced significantly in terms of emissions, and it's sort of a stopgap measure until we have more reliable infrastructure and industrial capabilities in that regard. Think green hydrogen, maybe. I'm not really sure. Solar, other types of things. So those are the types of projects that are getting challenged. We have a real division in our statewide and in our local communities, reflected here in a microcosm, on what constitutes the best methods for bringing power and continuing to power and use power within our grids, our local grids, our statewide grids. So it's sort of outside of the area that I've been working on, but super interesting. We also have the dubious responsibility of managing and operating actually it's the county sanitation district that manages and operates, but we own it. We have a landfill. And so that generates methane gas. So we're trying to capture that, burn it, which is an effective way of destroying methane, a potent greenhouse gas, and generating power, 12 megawatts. But folks don't want that either. So those are two large projects that have been challenged, received CEQA challenges, and that we're defending, along with a lot of infill projects. So we think about the Crenshaw case, and that was a larger infill project, right? Replacing an aged asset, a mall, with mixed use development. And we have a lot of little infill opportunities, and cities have a lot of pressure right now on them to comply with arena numbers. And we've just done our 6th cycle update of our general plan. And we have not yet heard from the Attorney General, who has sent letters to many people, people meaning, local cities such as Pasadena and others, who are not in compliance with the 6th cycle requirements to report on the availability of sites that can be used to meet the RENA numbers. So that's a whole other area. So I want to correct something that Neil said. He said our experts. I would call me a jack of all trades and a master of none, really. I get to dip in and learn a lot about something for a short period of time before I have to move on. So that is something that is very interesting, as well as ensuring that we can comply with the RENA numbers. And that, again, is very controversial. We see, I've been thinking, of course, a lot about NIMBY, but it's really expanded beyond NIMBY. I would call it NIMSY, and not in my city. I think that, these concerns are expanding beyond, just even a local or neighborhood concerns. They're really regional, they're citywide. Interesting this morning, and I'm gonna shut up because I could talk on for hours. The governor this morning was talking about water, water conservation and whether or not the state would be imposing mandates. And interestingly, he said, no, this really should not be a top-down proposition. We want to allow the local jurisdictions to implement. And I thought, I wonder if that will also hold true in the area of land use, housing, and planning. As and Anne is smiling because she knows, her clients are feeling the same way, that there are a lot of state mandates and requirements and hammers being held over our head now that the AG's been given significant teeth to enforce on such things as Pasadena declaring itself a landmark district, or the city of Woodside declaring itself a habitat for protected species and things of this nature in order to avoid SB 9's requirements and things of this nature. So yes, and SB 9, SB 10, and all the new housing laws, we're just trying to keep up with that. So that's what my practice in a nutshell involves. Some interesting, cases that are outside of my normal bailiwick, but are CEQA oriented. And so it's always, good to understand how CEQA applies in these various areas. And then coping with the new housing laws, of course, and fair housing issues, as we're discussing, which are always highly relevant with these projects. So something personal, I'll end with that. Well, I think I shared this at our last, at the wellness retreat. During the pandemic, I started to learn how to play the mandolin. So it's been a year and I still have a lot to learn. Let's just put it that way.
I love that when you said that at the meeting, I was so impressed because I have no musical abilities whatsoever. So the fact that you just picked that and stuck with it and are,
The operative word is started.
Yeah.
So thank you, Ashley. I'm going to shut up and give Annie.
No, we have a few more minutes. I was just going to ask you, why don't you tell about your involvement with the real property section?
Oh, of course, sure. Real quick. So as hopefully everyone on this call knows, the Real Property Law section, their flagship publication is the California Real Property Journal. And many moons ago, that's what drew me into the section, was my interest in the journal, and I became an editor. And then lo and behold, I became the managing editor and the editor-in-chief. And then after that, I got recruited into this to be an XCOM member. And the folks on the committee are as fabulous now as they were back then, many generations ago. But they, I don't know if this was a mistake, but they somehow elected me to be the chair for a year, and we managed to keep it running even during my tenure as a leader. But it's been subsequently passed off to phenomenal leadership, including Neil, who's on the call, Ashley, part of the leadership, and I just feel grateful to continue to serve as an advisor and have a great time with all these professionals across the state who volunteer their time for the betterment of us all practicing real property and land use law. So that's it.
You've done an exceptional job with what you contribute to the section, and I know Neil has been on the section committees for longer than even myself. But we're just very grateful to have you on the committee. And so I'll end with what would be some tips for some attorneys that are in private practice that may want to switch over to working for a city like you? What do you recommend?
Well, that is a tough one. The hits from the recession, the demise of redevelopment, a lot of cities just aren't hiring. I mean, they've been under freezes. So combine that with the economic impacts from COVID, and whether, as you know, cities are dependent on real property sales taxes, we have some revenue generating departments that charge fees, but that's really to cover costs. So and cities have a lot of challenges when it comes to covering their pension. Pension reform is a massive issue for many municipalities. So the switchover is not that easy, and It is, well, let's just say one thing, and I think I already said it, and that is that if you want to continue to learn a lot about a little or a lot about a few, you know, many things, it definitely challenges and stretches your practice. It keeps it fun and interesting. Let me just put it that way. I am not, you know, as I did as a young lawyer, sitting in a room summarizing depositions all day, every day, for weeks. I don't, you know, I'm not stuck doing a particular type of practice, and I get to mess around with many areas of the law and learn something every single day. So from that perspective, I find it super fun, interesting, challenging, so that's what I like about the municipal practice.
Do you feel like you have pretty normal hours that you work, or do you feel like you're working a lot of late nights, you know, because you're so inundated with less people working for you and so forth?
Right. You know, there's a common misconception out there that in-house lawyers don't work as hard as out-house lawyers, private practice attorneys. That's definitely not the case here in the city of Glendale. You know, and this particularly became true during the pandemic when we were working remotely. We were on 7/24, 365. You know, if something needs to get done, we were responding day and night to emails that are coming in. With the litigation projects, as the litigators out there know, you're working on it until it's done. Weekends, late hours, all night if necessary. We're on the business schedule, the business agenda of the boards and commissions, and of course our city council. So if there are items that are related to that, those things need to get done. And so salaried employees, it's different, you know. So if you have, of course, staff, they have set hours, you know, regular support staff, but you know, the working professionals, we work till it's done. And I'm very blessed to have, I manage the transactional division in our office, and I'm very blessed to have consummate professionals who are targeted to the departments that their client departments. So whether it's that Public Works Department or Glendale Water and Power, they are really resident experts in those areas. And I don't have to worry about management too much because that's who they are and that's what they do. So again, I find it interesting and challenging. I think it would be difficult. It's more difficult right now than it has been previously to shift over into the public arena. But it's a super satisfying and fulfilling career to have once you're in, if you find the right city. So I'm not sure if this is true everywhere. I just feel very grateful that I'm here.
Great. Well, thank you so much, Jillian. I really appreciate all that. And obviously your contact information is here on the screen if anybody wants to reach out to you or has additional questions. And obviously feel free to stick around for the rest of our presentation, so you can chime in on anything else that Anne might have to say or
I want to hear what Anne has to say for sure.
Okay, well, thank you, Jillian. I just have two things I want to mention. One, for people like me who are not familiar with the acronyms that are outside of my particular area, you kept saying about RHNA, which I assume is an acronym for something. What does it stand for?
Yes, it is Regional Housing Needs Assessment.
Okay,
so yeah, so Regional Housing Needs Assessment. So Southern California area governments, they perform an assessment to determine whether the amount of housing that areas will need, and they just try to, well, I guess, distribute it equitably, but there's a lot of controversy and questions about whether that distribution amongst municipalities is in fact equitable. So the determination that the city needs to make, and what we made it in the 6th cycle of our housing element update, was whether or not we had the zoning to accommodate the number of housing units that, not that we would develop it, just to show that if private development were to come in, that that number of units, that number of the zoning would permit that number of units to be developed.
Okay, thank you.
Right.
And zoning leads us perfectly into our next case. But before I do that, you had mentioned your involvement with the Real Property Journal, and I'm not going to call on him, but our journal editor-in-chief is actually on the line today. And so on his behalf, I'm going to say, I know we're still looking for articles for, I think, issue 4, which comes out at the very end of the year. So if anyone's interested in writing a really high quality kind of law review type journal article, you can contact me and I'll make sure it gets to our
Norm Chernin.
So, okay, so great. So let's go into our next case. Try and do that. Here we go. Okay, and so what do we have here? We have Protect Our Neighborhood versus City of Palm Springs. And this is basically a short-term rental case. You see some of the facts there. So what happened here? In 2016, Palm Springs amended its ordinances to specifically say, well, short-term rentals only allowed for single-family residences or duplexes, and limited the number of short-term rentals for any one property per year. It's interesting reading through that ordinance. There's sort of an exception at a certain part of the year. When would that certain part of the year be? What do you normally think of? You know, Palm Springs, Coachella Valley, you think of the big music festivals, right? So it seemed to me that I think that's about where the certain exceptions were located. But of course, a lot of people are not really crazy about short-term rentals, right? I got my little graphic there of a noisy neighbor, and I think everybody knows somebody who has a property that's next to a short-term rental, and they complain a lot about it. They complain about, you know, nuisances and at least a stereotype that people doing short-term rentals are not as considerate as permanent owners in a neighborhood. So this group, Protect Our Neighborhoods, filed a claim against the city, seeking injunctive relief and saying that the ordinance violated zoning code. The trial court made a decision. There was a hearing, it was a documents-only hearing. And it said, you know, one of the neighborhoods' argument was, well, that's a commercial use. Commercial use is not allowed in residential neighborhoods. And the trial court says, well, it's not a disallowed commercial use. And by definition, it was deemed to be basically, you know, a secondary and ancillary use, which is specifically allowed under both the zoning and the ordinance. Protect Our Neighborhoods appeal, the appellate decision affirmed. One of the arguments that Protect made was that there was inconsistencies between the zoning law and the other ordinance. And the appellate court said, well, it's not that one really supersedes the other inherently. They're co-equal laws under the local law. And so maybe there's an implied repeal for inconsistent terms. What was the later one? The later one was the short-term rental ordinance. And Ashley, I know you know a lot about short-term rentals. And so why don't I let you take over, and I'll put myself on mute, and then we'll let our guest speak.
Yeah, so this case is actually really important because there has been a lot of discussion in the past with cities and different homeowners associations regarding whether short-term rentals are commercial use in nature. And so I think that this is going to be really impactful going forward in rejecting those arguments that, you know, short-term rentals are commercial in nature like a hotel. The case, you know, talked about how the short-term rentals are pretty much kind of on a one-by-one situation. In a lot of cities, they're restricted in numbers as well. So it's not like a hotel where you have 50 to 100 guest rooms of all these people staying in one place at one time. It's obviously when you have the bigger mansions and things like that, that's slightly closer to maybe more of a hotel situation. But when it's just a single family home or a condominium where you have renters, they're saying, you know, that is akin to leasing your property to long-term renters. So it should not be prohibited, you know, as a commercial use, which that's what I've been arguing for my clients for a while. And I think that this case will be really impactful in that regard. And I mean, Palm Springs has been one of the oldest cities to enact short-term rentals. So they are one of the first cities, I should say, to enact short-term rentals going back as far as 2008, before Airbnb was really even a thing. So I think the court came to the right decision on this case. I think it's going to be really impactful going forward, especially with homeowners associations. And I noticed that you mentioned there at the bottom, the prohibition of the short-term rentals in coastal zones now requires coastal commission approval. And that was based on a Greenfield case, which I think was in 2018 or 19. But it sounds like there might be another one that's coming up that's similar. So that's been really a big deal in San Diego, especially having homeowners associations that completely restricted short-term rentals that are in the coastal zones. So
Ashley, it's interesting to me that this case was where the city was specifically allowing them. Most of the cases that I've seen has been where the city is disallowing these short-term rentals. And you also mentioned, the commercial. There was an older case, I can't remember the exact name of the case. It is cited in the Protect Our Neighborhoods case, something with Carmel by the Sea. And the court did a very good job distinguishing that case that came to a different result. So for those who are looking at the definition of commercial, you might want to look at that older case and see how Protect distinguishes its result from that in the Carmel case. And let's see, do our local government attorneys have anything to say about this, one way or the other?
No.
No? Okay. All right. Well, then, you know what we're going to do? We're now then going to turn it back over to Ashley, who's going to interview Anne.
hi, Anne. Thanks for being here today.
Glad to be here.
So I'll ask you the same thing as Jillian. Why don't you give us a little overview of who you are and what your practice entails, and then I'll give you some additional questions. I know we wanted to discuss some intricacies about the differences of being an outside counsel to a public entity, which most of us are probably not familiar with, and I've only recently had an experience with. So why don't you start on you first?
Well, I graduated from University of California, Hastings in 1977, which tells you how old I am. I was really, that came to fruition when I went to sign in for a continuing education program. My bar number is 77114, and the new attorneys were in the 400,000 numbers. So it was like, oh, really? But I've had fun. I became a partner at Rutan & Tucker in the real estate department and represented developers and lenders, particularly construction and development loans, which was really interesting. During some of the downtimes in private practice for real estate, which is cyclical, I started working with the public law department at Rutan & Tucker and got some background in public law. In '97, I moved over to First American Title Insurance Company as one of the senior underwriters, which was a lot of fun because that was less advising of a client than making the risk decisions myself. And so it was a lot of fun. I was there for 17 years. That's where I met Norm Chernin. And I met Neil because I also worked with Neil with the car contract, the RPA becoming joint escrow instructions. Because when I was at First American, it drove me nuts that you would have the RPA and then you'd have separate escrow instructions, which sometimes and very often were not consistent. It made no sense. And so I got to know Neil very well then, and then toured with CAR for a short time period, teaching about the new CAR contract as to the new title policy that was the default policy, and also the escrow provision. So that was a lot of fun. And things changed with First American quite a bit, and I decided to go back in private practice with two of my partners from Rutan, Dave Alshire and Bill Winder, who I knew and respected for a long time. They had started the firm, and this firm is now up to over 50 lawyers and representing a great number of different cities. And so I came in, initially, they didn't think there'd be a lot of real estate. They underestimated how much real estate was really there and that it required expertise to deal with it. And so it's been very interesting. It's helpful because I I know how a lender thinks, I know how the developer thinks, and I know what the title company wants, and I know what the city wants. So it's helpful with that background to help craft solutions to problems. And it's, as Jillian said, it's a lot of fun because you never know what's going to happen next. I remember dealing with one city in which they had incorporated, and they drew the lines down the middle of a county road for one of the boundaries. And under California law, the boundary, everything inside that boundary automatically becomes the road belonging to the city. Well, the other half of that road belonged to the county, and the county vacated their half of the road. So it's half of the time, or a good number of times, I've had staff call and you want to go, you guys did what? But it's creative and it's fun and it's very interesting. And it has so many different aspects of real estate. Primarily mine is real estate transactional, not litigation, but become involved in those other cases peripherally. Fortunately, I don't have to go to city council meetings, which if any of you have sat through those, that can be an interesting challenge. So she laughed. I respect my partners who are city attorneys, and I am more than willing to be the back room person who does the real estate and gets it closed. It's really an interesting challenge, although they have some fun stories, I must admit. I enjoy the public housing aspect of it, dealing with affordable housing, which is very complex, or can be. And so many of the aspects of city work does involve real estate. So it's really one of those situations where I'm still learning new things about real estate, which makes it a lot of fun. And unlike Jillian with the in-house with a city, our firm does hire and would be looking for people who would be interested in coming into a firm that does only public law work. And we do represent cities and governmental agencies, water districts, you name it. And I will admit that it doesn't, public law firms are not allowed, representing public agencies do not get the high billing rates. But the nice thing about it is that the work is always there and they pay their bills, guys. You don't have the problem of trying to collect fees very often from a governmental agency. So there's a counterbalance to risk in any kind of work, but it is fascinating. And our associates get to try all sorts of different things, litigation, enforcement actions, real estate. And I'd love to have some real estate people because it's becoming quite a big practice. So as to something personal, I think probably the thing that most people find the most unusual is my husband and I have been going into juvenile hall to do religious ministry to the kids in the high security units, and have for a number of years, and find that very rewarding. And can't think of much else to say. If you have any questions.
No, that's so great that you give back to the community and are able to contribute that, and especially people who probably really need that resource. So that's great. And I love that you worked for First American Title. I mean, I've always thought how interesting it would be to switch over and working on the title side at some point if I don't want to practice law anymore. But I work so closely with title officers, and I'm sure many other transactional attorneys on here do the same, and how valuable those people are to helping your transactions get completed. So I'm sure you have some great insight in your cases with that background.
Well, title insurance, as you know, is the tail that wags the dog in real estate. It's nothing's happening if it doesn't close, if the title policy is not issued. So it's helpful for the background to understand. I know what they need. And I also know most of the senior underwriters, so I can call them directly and try to finagle what I need.
It's awesome to have that inside track.
Yeah, it is helpful. I would like to take just like 3 or 4 minutes just to highlight a couple things I learned from going from the developer private industry side to the governmental side. It's sort of like passing through the Alice in Wonderland mirror, and you have to realize that the government is not the same as dealing with another private entity. And so just a couple of highlighted items, which I found that a lot of lawyers don't realize. You know, governmental agency, you cannot stop them. And you need to be aware of that, especially with staff making statements or something. That's not going to be binding on the city council. And it's the city council who is the decision maker. And if there is, you really need to have the expertise of someone who has public law background if you're dealing with a governmental agency and doing a big deal, because they're not going to tell you where the, you know, and they have no duty to tell you where the weaknesses might be, or a public law lawyer may be able to tell you, look, you need to do this or that. There are things called validation actions, which the city can bring, and they are usually done for confirming financing type situations, but there's also a reverse validation action. Can't go into all this stuff in extensive detail, but the CEV book that's available on municipal law will be very helpful if you need to deal with a governmental agency. Go through that book and check out what you're doing. There's no prescriptive easements or adverse possession against a governmental agency. We had a tenant that was in a building next door, and they had been using the city's parking lot for 20 years. They thought they had a prescriptive easement. Not so. There's a civil code 1007 that prohibits that. So understand that your clients cannot have the same rights against a governmental property that they do potentially against a private property. Leases of governmental property in California have to be recorded under the government code 37393. And there's a real, not if you're leasing to the governmental agency, but the reverse, if the city is leasing out property. And it's a very simple reason. It's because their property is exempt from real property taxes, and that can't pass along to a private entity. So there's a possessory interest tax that's assessed, and they pick that up from the recorded lease document. So FYI, your client, if they are leasing from a governmental agency, is going to be paying possessory interest taxes.
And if I could just have you clarify, it is,
Sure.
is the, whether a memorandum of the lease or the entire lease are sufficient?
Well, the government code isn't real clear on that. And I've had some client cities that say they just want to record the memorandum. Real estate lawyers hate recorded documents because they're too hard to get off the title later on. So trust me, this is not something that I favor, but it is important for it to comply. So in the lease, I always do put that they have to cooperate with terminating it. But one city wanted to just record the memorandum and say it's available for public view as a public document at the city hall. Most of the rest of them, because they don't have any recording fees anyway, they just record the whole lease. So it's not real clear. It does say that the lease is to be recorded, but I've had some cities say they just want to do the memorandum, which still impacts titles. So you need to get that off.
What would you have to record to get it off? Would it just be like a rescission of the lease or something like that, revocation of the lease?
Well, if you actually have in there that it in the recorded memorandum, let's say that it automatically terminates on such and such a date, oftentimes the title company will take that out. Sometimes they'll rely upon a city giving a representational warranty and a certificate that it has in fact expired and their tenant's no longer in there. But it's just one of those things. Real estate lawyers tend to not want to clutter title because of potential problems if they go to sell the property or lease it again or anything like, or borrow against it. So I always put in a provision that the tenant is obligated to execute a document if requested after the termination that can be recorded. So one thing that if you're actually selling property to a city, understand there's no documentary transfer tax due. As you know, that's $1.10 per thousand. And if there's an exemption under Revenue and Tax Code 11922, and the title company and escrow is not going to pick that up. They just impose it because that's part of their standard practices. There was one sale going on where one of the cities was buying a $25 million $35 million building. And by accident, I saw the seller's closing statement, and they had documentary transfer tax on there of what, $38,000. So I called him, the other attorney, and said, "This isn't applicable. You should tell him to take this off." I thought he was going to climb through the phone and hug me, but he was very grateful. I can say that. But a lot of real estate lawyers don't realize that that exemption applies to them when selling to a governmental agency. So just FYI.
I have one of those coming up, so thank you for that tip.
Marketable Title Act does not apply to governmental agencies, as many of you know, or maybe well, the title people know for sure. There's Marketable Title Act that certain outside dates apply for documents that are recorded that kind of expire or don't have any continuing effect, options, covenants, and terminable interest. And so there's the Marketable Title Act, which is in the Civil Code. And it's important to know that does not apply to governmental agencies, because governmental agencies, it's not that they're asleep at the wheel, but they have so much going on that they may not be paying attention to that kind of an interest that they have. So it does not apply to them. And one last thing, Subdivision Map Act, you gotta love it. Everybody knows you gotta comply with that, except governmental agencies. They can actually transfer land by meets and bounds descriptions, and it is insurable by a title company, although the title company usually is going to ask for the city to issue a certificate of compliance, so it's absolutely assured that it's a legal parcel and the city's going to view it as such. So those are just some of the kind of highlights of things that I came to realize and understand more because I joined the city side or government side. And I did not necessarily know when I was dealing transactional law for developers and lenders. So just a few tidbits out there for you.
And I'm going to add one thing to that list. We can also, as a governmental entity, cities can do what's called a parcel map waiver. So we can streamline the creation of parcel maps by doing a waiver process. And that's in the Subdivision Map Act as well.
Well, I think we need both of you to do a webinar on this, because I don't think there has been one on this particular topic. And this is fascinating to me and for many attorneys that probably are either on the other side of the transaction, not knowing to look for these things.
Yeah, and there's a few more out there, but I wouldn't mind helping with a webinar, because it's always nice to pass on education. And well, I can still retrieve all of it from my memory bank. I like to share it.
Well, I will be in touch with both of you offline about that, because I think that that would be a really great seminar, and I would definitely be interested in watching it. So
you can call it from the other side of the looking glass.
Ah, clever, like it.
Well, so Ashley, you definitely should be in real estate because you're always closing. Way to go. Way to go. I like it. I like it a lot. Thank you, Anne. I mean, Anne is fascinating. And just, you know, Anne just mentioned one of the very many things that she does, you know, as a public service. And Anne is not a Johnny come lately. I remember her telling me years ago about her and her husband and their work, you know, with these facilities and juveniles, and it's really a marvelous thing. And Anne talks about there's great stories. Anne has the stories. Anne has the stories. She's not just relaying somebody else's stories. So thank you very much, Anne. You know, we have a few minutes left. We're not going to go into this whole slide here. This slide was basically, Jillian mentioned that the Attorney General is getting very involved in state housing issues. And this is just some of the things from the Attorney General's website showing what they've been doing. The Attorney General exercising kind of its muscle. And do either of you have anything to say about, is this unique? Is this something that just started? What are the city's reactions to what the Attorney General has been doing?
I would say, go ahead, Anne, go ahead.
No, you go first because it's more from a litigation side. I was going to talk about the effect of some of the the new bills dealing with housing and the problems that it's bringing into the cities.
Sure. It kind of goes hand in hand. There's a lot of dismay and concern, as you can imagine. And some of the reactions out there, we're seeing it locally. City of Pasadena, the first note there is the Attorney General applauding their move to come into compliance with SB 9. And of course, what they did is they merged two express exemptions for SB 9 for an individual site can be exempt if it's a landmark property, if it's a historic property, or a historic district. So what Pasadena creatively did is they exempted landmark districts, which don't exist as an exemption under the SB 9 rules. And they, so they modified it and they came into compliance, but then within 10 days, the Attorney General sent them a letter letting them know that they had problems with their, they were violating state housing laws for non-compliance with their update to their 6th cycle housing element. So I don't know what the status of that is right now, but it is, you giveth one day and you taketh away the other. So I think there are a lot of creative reactions to, the requirements of SB 9 and some of the other requirements that are out there. There will be a lot more litigation, for example, on the Housing Accountability Act. So we just have to keep staying tuned, but the cities are trying to pivot. And Anne's going to talk about some of these concerns, so I'll turn it over to her because I know we only have a minute or so left.
The other, I forget, correct, Jillian, the SB 7 or 8, the one that allows additional dwelling units and further subdivision. Oh, is that 9? Sorry, I'm really bad with case names.
9 is the 9 is the duplexing on site. 10 is the you can split your lot if you meet certain requirements.
Right. Which, for most of our cities, are very concerned less with that. It had very little thought, because when developers come in to develop an area, the infrastructure is intended to service a certain number of people. And virtually this additional dwelling units and additional subdivision within the lot doesn't deal with any of that. It doesn't say that any of the people have to go and make sure they have will serve letters. Who's going to pay for the expanded utility services and street wear and tear and all of that? So the cities are struggling with putting in requirements within their code for applications for these kinds of things. And so it's having a severe potential adverse effect, and it's going to have it on traffic. Nobody's paying attention to that either, or parking. What about the schools? So when developers go develop, they have to pay impact fees to offset those effects on a governmental agency, a city. And that's not being required here. It was sort of sounds like a good idea, but they really, are creating some additional problems that are being struggled with by the local agencies.
So with that view on potential unintended consequences, we have to end us today. We could have probably used an hour and a half today, but that's not what we do here on What's Up With Us. Anybody who wants a copy of the presentation, it is being recorded, or if you want a PDF version, you can send us an email and we can get you a copy of that. Here's what's coming up. Don't have time to go into it. We talked about already about hopefully somebody will be interested in writing an article for our journal and getting otherwise involved. Next month, we're going to have Mary Beth is going to talk about our real property law section GEI panel. So those of you who have that interest will want to join us next month. And when is next month? Wednesday, June 15th. Thank you, everybody. Goodbye.
Thank you. Bye-bye.